Mr. Chume, just before we resume, I omitted to say at the beginning, I hope the parties know this. If they don't, I hope it doesn't cause any problem. The court needs to sit early tomorrow. In fact, I think it does show on the list as 9:30, because one of us has to leave at 3, so we will have a full day, but rather front-end loaded. We may have an early lunch. We haven't thought about the details of that. I hope that's not a problem for anyone getting here by 9:30. Whether it is or not, that's what's going to happen. Okay.
Thank you, my lord. We were looking at Adamson and Jarvis, which is
yes.
A1 tab 5.
Yes, and we have indeed read it over lunch. It's the same point, isn't it? He does indeed say what he's quoted by Lord Justice Cotton as saying in the Birmingham case. And it does say the point to which you no doubt attach importance about all losses, but the actual context was where he was the auctioneer had to pay the true owner the value of the goods which he had sold in good faith.
Yes, my lord. That's...
What else do we need out of it? What other points do you need to make out of it?
The only other point that I had coming out of it, as your lordship says, it's the reference to indemnify against all the consequences.
Yes. Yes. Well, I see that says what you wanted to say. The question is how much weight we put on that literal meaning when we see the context of the dispute in which it arose.
Yes, I was going to take your lordship to the contents of the dispute and just look at what was recovered. One sees that page. It's internal page 694. In the bundle, it's page 16. And yes. It's the first full paragraph down, which says that afterwards, to wit, on the 23rd of November, in the year last aforesaid. And then it sets out a list of that which, as I understand it, was what was recovered under the indemnity. And,
yes, okay, let us just read it. It's 2 items, isn't it? It's the actual price or value of the cattle, which is the wait a moment, sorry. £11,000 is the value of the goods sold, which actually isn't just cattle, and a further £95 for the true owner's costs in bringing a claim. And then there's £500, which seem to be his own costs in defending the claim. Is that right?
Well, on my reading, that there are 3. I agree with everything your lordship has just said, but if the £500 is in and about and defending the said action, so brought against him, that's clearly the legal cost. But then it says, as last aforesaid, and in and about taking and pursuing other necessary proceedings made incumbent upon him in consequence of the said sale and the said recovery, of which all the premises, and then so on. So in my submission, it's slightly wider than the damages and the legal costs. There are also these rather, I accept, unclear sums that were not just in consequence of the said recovery, but in consequence of the said sale. And so that does add a bit, I say, to as Chief Justice Best saying it's all the consequences, not just some of them.
Yes, thank you.
The next one, what can't be said against me is that these cases aren't interesting, because the fact situations in them seem to be fascinating. But the next one I was going to take the court to was the Frixioni case. I'm roughly following, I think, kind of chronological order. So that is in bundle A1
yep.
at tab 6. it's an agency case. It's a privy, as I understand it, it's Privy Council on appeal from the Royal Court of Appeal of Malta.
Yeah.
And the members of the Privy Council, I think, are set out at the bottom of the first page, page 20.
Yeah.
It is quite dense, but in outline, the facts are simple. I'm just wondering, I was going to sort of describe them, and then, because
well, if you can summarise them briefly, that's much better than us ploughing through them.
Yes.
The head note is wonderfully succinct.
I was about to say it is all there in the head
been
note.
sidelined.
I mean, the head note tells us all we need to know about the points of principle, though you may well decide, you may well want to show us the underlying reasoning. Do we need to know about the fascinating facts? In fact, I see that it also, echoes of today, involves the port of Kerch in the Crimea. But you must tell us. I mean, we don't want to read more than we need, but if the stuff we need to read, you must take us to it.
Yes. Well, I'll just give my additional points apart from the head note. As one sees, the agent Friccione in Genoa was tasked by the Tagliaferro to sell the cargo of the Genio. He contracted to sell it to Pisano. Unfortunately, the Genio arrives late, and Pisano sues for the loss of profit he'd sustained because he could not complete an onward sale of the cargo. And a couple of the points that I wanted to draw attention to were that yes, the liability, first of all, that Friccione had to Pisoni, we see at the bottom of page 25. He was sentenced to pay the appellant, sentenced the appellant to pay Pisano all the loss and damages sustained by him in consequence of the breach of contract, together with costs.
Yes, but that's Pisano's claim.
I understand that. My point is, and one may say it doesn't go very far, but if one is thinking about limits on this indemnity, then what's important to appreciate in my submission is that it's unlimited, even on the defendant's, even on the respondent's case, if it covers liabilities to third parties. There's no limit to those, and they may be for loss of profit. They may be if you've injured someone in the course of carrying out your instructions. They may be for loss of earnings. So they're the same type of loss. I do appreciate, of course, that they are falling within the scope here of a liability to a third party. My point is, it's an open-ended liability, and that does have that is important if one is concerned about the strict liability nature of this. There are a couple of other points on the facts which come out. One sees this really from 27. I appreciate it's in the argument of the council, but it's just interesting to observe. If one looks at page 27, near the top of the page it says Sir Frederick Thesiger QC and Mr. C. Pollock. And if one just reads down the first few lines there, it is clear that in this case it was accepted that Mr. Friccione had departed from his express instructions given to him. But certainly as I understand the case, that did not stop the Privy Council saying that that this case fell within the scope of the implied indemnity, because he was still acting within his authority.
If you say so, but under the head note, I thought that was because the principal had waived or ratified the departure. But we've read this fully and we haven't.
Well, that's part of it, my lord. I was just referring to the top of page 28.
Sorry, I see. Well, now I just want...
Your lordship is correct. There was a departure from express instructions. He was nevertheless acting within his authority. And thirdly, I think that authority was ratified. I just thought it was relevant that there had been a departure from express instructions.
Why?
Because it shows that the indemnity can still protect. I mean, it's not relevant, I suppose, to this case, but it was just an example of the width of the indemnity, that provided that the agent or employee is acting overall within the scope of their authority, the fact that they depart from express instructions may not be an end of the indemnity protection.
Speaking for myself, I don't understand that. If that's what the Privy Council said, so be it. If they departed from their instructions, then they weren't acting within the scope of their authority.
But if the agent goes beyond his instructions and the principal waives the excess, then that's all right. Yeah. That's what they say on page 29, and about halfway down the page. I wouldn't claim to be an expert on the law of agency, but it strikes me as uncontroversial.
Yes, my lord. I'll move on to my next point. I was going to draw attention to the fact that on page 28, in the middle of the page, there's a paragraph beginning, "Then it is said that they did not understand what the effect of the contract was, as they were unacquainted with the law of Sardinia." And again, that seemed to me to have something to say about whether foreseeability is in any way relevant to the application of the indemnity. That's a matter that we come on to in ground 5, and what I suggest is, not based solely on this paragraph, but this is just an example of it. It doesn't. Foreseeability has nothing to do with it. So whether or not you know the law of Sardinia is tough luck. As it says, they understood the effect of the contract they made. It was their own contract, and they were bound by it. The third point that I wanted to make is that if one looks at on page 29, and this is the penultimate paragraph of the judgment, it says, "It is said that the sentence of the Court General is erroneous in law, but this is immaterial, nor is it material to consider the effect of the sentence of a foreign court on the court at Malta. Be that sentence right or wrong, the appellant thereby sustained a heavy loss on behalf of the respondents, and they must bear the consequences." So, again, I point to that, partly in answer to one of the points that your Lordship raised with me this morning. And then the third point, the last point on this.
Sorry, let me just spell that out. How does that read over into this case? reads over that you don't have to, although it is your case that it was wrong, you don't have to show it was wrong. You simply say you incurred the liability.
Exactly. We say it's a fact. There is a conviction with these consequences. We don't have to. Our case is it's wrong. We don't have to prove that. Precisely, my lord. And then a point on which the judge didn't find favour with my submission, but it seems to me it's not entirely a valueless point, is that one sees at the end that this is the last paragraph. Their lordships regret that in a case so clear in law and in justice, the appellant should so long have been kept out of the money to which he was undoubtedly entitled. And what I say about that, and the judge says, well, that's just an award of interest on the principal sum, and you don't derive anything from that. I see that, but my point is simply that that may be so, but it doesn't change the characteristic of the award of interest. The award of interest is not a payment out. It is not a liability to a third party. It is a loss you have suffered because you didn't.
Well, no, surely the award of interest goes with the liability to the third party. You were liable to the third party, and had to pay. The interest was surely on the. What was the interest paid on?
No, the interest was on the sum
that they'd had to pay from the time when judgment was entered in the Court of Genoa. I see. You make a point about when.
What the point I'm making is that as I apprehend it, and as the judge and I did, what happened was Friccione got back the money he'd had to pay out to Passoni, but he was also awarded interest on that sum because he had to pay it out for some time, and it had taken ages for the dispute to reach a resolution. The interest here is not interest on the amount he owed to Passoni. It's interest on the fact that he paid out, and he had to wait until he got this judgment to get his money back from Tagliaferro. And so he was awarded interest. And the judge said, well, that's just the award of interest on the principal sum. I accept that. But what I'm saying is it doesn't detract from the nature of that amount. It isn't a liability to anybody. It's only a loss to you. It's not a payment out. It's a loss you have suffered because instead of having the money he had to pay out to Passoni to put in the bank or invest, he hadn't got it. He'd given it to Passoni. And so he's awarded interest. So one can't get away from the fact that the nature of that amount of money, whatever it was, is in the nature of a loss suffered only by Friccione. That's my point.
When a court says, the Privy Council says the amount of damages shall be ascertained, what are they referring? It's an antepenultimate line.
I don't know, my lord. My assumption would be, although because I assume he was recovering for the legal costs as well.
Yes.
And those probably needed to be worked out.
At the very beginning, Pemberton Lee says to cover the amount of damages sustained. Well, I suspect nothing turns on any of this. I just wanted to understand it.
Lord, I think the answer is at the top of page 26.
Yes, I was just looking at that. Yeah, thank you. Yes, thank you.
I was going to go next to look at the case of the James Seddon, which is the next tab over, tab 7. The facts are set out in the head note.
Speaking for myself, I'm pretty sure, as we mentioned it, my lords as well, we've read this.
Yes.
So you needn't tell us the facts, unless there's particular facts you think we might have missed.
I was going to say that it's worth a careful reading, because although the head note it says the master was entitled, in the held section it says the master was entitled to the expenses of his defence on the ground that the charge originated directly. In my submission, when one looks at the facts, in fact he hadn't paid the expenses of his defence. The circumstances, and I accept that this is perhaps inference, but the only way this report makes sense is as follows. The master of the vessel was tried and acquitted on a charge of murder by one of the crew, the prosecution being based on the testimony of the disgruntled crew members. The costs of the legal defence were paid by the agent, in this case called Arbuthnot, and one sees that from page, in the bundle it's page 32, internal page 64. It's the end of the submissions, just above where the judgment of Dr. Lushington is. As to the £10, the claim was paid by Arbuthnot as agents. They paid the fine in order that the master might come to England. The law charges were also paid by the Arbuthnot's. It's unlikely that the master had agents. These presumably were the agents of the owners. And it is they, the agents, who would encourage the master to sell. One sees that on page 63, second paragraph down. However, the trial came on. The vessel had got all her cargo on board, valued at about £100,000, which seems an extraordinary amount of money at the time, and was ready to sail. And the agents, Messrs. Arbuthnot, urged the master not to delay, but to depart and forfeit the amount in which he had been bound, and he accordingly did so. So in my submission, what's probably happening is that on return, the master asks for his wages, and the owners seek to deduct the money paid by their agents. The registrar ruled in favour of the master, and then, as we see, this was a motion on the part of the defendant, the owner. So the owners complain about that and bring the case before Dr. Lushington. So points to note, as I said, the master didn't actually appear to pay any of these amounts. The £10 forfeited was described variously, I think, as a penalty. That's at the bottom of page 66, and a fine at the top of page 64. The reason I draw attention to that is because of the discussion we had this morning about whether or not the indemnity would cover a fine. And the answer to that in my submission is clearly it would, because whether you call it a penalty or fine, it was in the nature of that, the £10 that the master forfeited. he could have stayed there and taken part in the prosecution, but he said he sailed and that money was lost, which he hadn't even paid. So what's interesting is that this is a really good example, in fact, not of reimbursement, but of the hold harmless principle working, because what happens here, clearly on the basis of page 64, is that the master didn't actually pay for the legal costs, they were paid for him, and he didn't pay for this penalty.
Well, Dr. Lushington doesn't seem to draw a distinction. I mean, in the most eloquent passage in the judgment, page 65, he says large expenses are incurred by the captain in defending himself against this false charge. Obviously, equate whether the money was actually put up by him or by our banknotes. Dr. Lushington treats it as having been paid by him in defending the prosecution against him.
Yes, my lord, but that's really my point, is that one sees that the suggestion that the indemnity operates only in relation to a payment you've actually paid out clearly can't explain the case. And similarly, it's not clear whether or not he was liable to make these payments out. He might have been, he might not have been.
Is it part of anyone's case that the money has to be actually paid out? Maybe it is, but I'm not master of what positions people have taken during this case.
Well,
I thought it was enough that there was a liability.
It is. The defendant, the respondent's case is that the payments out are limited to sums you've actually paid out.
Is that?
As expenses, or
I hadn't understood that, and Mr. Goulding is frowning.
Yeah, or liabilities that you incur that you would have to pay out on.
Yeah, well, he would. If the money wasn't payable by the owners, agent clearly he would have been liable to the agents for paying out this money. Either it was within the scope of his authority from the owners, or it wasn't. If it wasn't, then he was liable to the agents, because the agents weren't liable to pay anything for him. Their job was to discharge payments which were the liabilities of the owners.
I see that, but the point is that we don't even know whether that liability was formally created. I accept that it may be in a different factual circumstance. It might have been that he had to pay the lawyers, but the point here I'm making here is the breadth of the hold harmless principle is that even if you are subject to a potential liability, that falls within the scope of the indemnity, shown by the fact that the agents in fact paid for everything. It doesn't go any further than that, but in my submission, that is a slightly different position.
With all these cases, Mr. Jimmy, this important principle of law can't depend on working out tiny reading between the lines of all these cases. We're looking for issues of principle here. We've already established, as you conceded from the start, that they actually don't directly address a claim that a kind is being made here, but you say, never mind, the statements of principle made by the court do. You haven't shown us any relevant statements of principle. You say, oh yes, but you can infer this and you can infer that from this on the facts. That's not the way precedents help this court.
Understood, my lord. I'm sorry.
I suppose what you say is that the principle is that the indemnifier must render the indemnified harmless, and that means that they have to indemnify them in respect of all the consequential loss.
That's it.
All the consequences.
Yes.
Well, look, you may or may not be right about that, but I think we understand what the principle is. I'm afraid that, like my lord, I'm not sure how showing us lots of specific cases which don't even on their facts actually take things any further than that principle is assisting us. I'm sorry.
Understood, my lord. I will move on.
There seem to be plenty of cases to show that the employee is entitled to an indemnity in respect of sums which he has been required to pay out, whether pursuant to a civil judgment or a criminal fine or a liability to lawyers for costs, being examples of that. The question is whether it goes beyond that.
Yes, my lord. Got it. I will attempt to address that. Just before I do, and before we leave this case, I appreciate that you'll have seen this, but can I just draw the court's attention to, at page 65, in the middle of the page, there's a passage where Dr. Lushington deals with the very direct connection between the loss and the performance by the master of his duties. And that, in my submission, is something that's important, even though I appreciate this case is going to be confined to its facts.
What's the particular? I've got page 65. Where? Sorry.
Yes, it's where the lines are. It says, in the first instance, I apprehend that the causing these men to be censured and chastised was part of the bounden duty of the master, and it continues down to the passage which says, well, it's really the whole of that passage.
You see, this is the distinction I was trying to draw this morning, which the respondents may or may not accept, but I can see the distinction that where you incur expenses in defending yourself, well, that does fall within the scope of the indemnity. But you have to go well beyond that and say that loss of future earnings comes within the scope of the indemnity as well.
Yes.
And I'm not sure I see that in this passage anyway.
You're correct, my lord. One doesn't, but you do see this focus on the importance of the direct connection between the performance. That's the only point I was trying to make on that. What I propose to do is to go forward to look at some cases which we say address the point that your lordships have just pressed upon me, and those start in bundle A1 at tab 11. This is the case of Burrows and Rhodes and Jameson. Again, it's quite a dense case. The head note doesn't really assist. It may be worth looking at. The background facts are fairly simple. The plaintiff, Burrows, was seems to have been a mercenary, but he was encouraged by the defendants, he said, Rhodes and Jameson to take part on behalf of their company, the British South Africa Company.
This is the Jefferson Raid, is it?
It is, exactly, my lord. The Rhodes, I believe, is Cecil Rhodes.
Yes, right.
Yes. So the Jameson Raid was an unmitigated disaster, I believe, and I think led to the Boer War, the Second Boer War. And Mr. Burroughs was on that raid, and one sees what happened to him at paragraph 8 on page 74.
So he joined in the raid, he says, thinking he had the support of the government.
Yes.
A matter on which historians, I'm not sure how divided they are, actually. Anyway, yes.
And he had a very bad time. He was taken prisoner, he lost his leg and was severely wounded. He was liable to summary execution, thrown on the streets, returned to England and found himself liable for severe punishment, and returned to England as a prisoner. And his claim, we see at the bottom of the page, was a claim for loss of earnings.
Yes, the cause of action was fraudulent misrepresentation. You see that from the headnote.
Yes, but when one actually reads the authority, one sees that, in fact, the discussion was about whether or not the claim for an indemnity was demurrable. In my submission, that's why the headnote isn't very good here.
Well, you have to be careful with the word indemnity. Indemnity is sometimes simply used as a paraphrase for damages, particularly in the older cases. He wants to be indemnified against his loss, but all that means is he wants to be compensated for his loss, fully compensated. I'm sorry, I'm just speaking aloud. This is one of the cases which regretfully, because it's obviously very interesting in itself, I didn't read beforehand. Lord Robert Cecil was junior for the defendants. He must have been related to Lord Salisbury, who was the Prime Minister at the time. Anyway, that's all by the by. Where take us to the passage you were going to?
As I said, it's not very easy to see, but and I accept what your lordship says, but if one turns to the judgment of Mr. Justice Kennedy, starting at page 83 of the bundle pages and 827, and I also accept that this is only about whether the claim was demurrable.
Yes, but the first sentence of Mr. Justice Kennedy's action shows that his judgment shows that the claim is a claim for fraudulent misrepresentation.
It's not what may have been partly for an indemnity, but not entirely. You can't be indemnified against the loss of a leg.
And indeed, we see the rather old-fashioned language. The penultimate line of the first, he talks about whereby he was damnified in various ways, which set forth in the statement of claim. Anyway, yes, so...
I see all of that, but if one looks at the bottom of page 828...
88.
84 in the bundle pages, forgive me. 84 in the bundle pages. The discussion there, in my submission, does relate, or is relevant to the scope of the indemnity we're discussing. It says, the bottom of the page, it says, in the next place, it is, I think, also clear that an action for indemnity, grounded either on deceit or warranty, may be maintained where the party who seeks the indemnity has incurred damage by reason of his having been authorised or, as alleged in this action, fraudulently induced by another to do an act indifferent in itself, which has turned out, because it constitutes a private wrong, to be unlawful.
But sorry, I'm Another one taken as, we must understand how the procedural context in which it arose.
Of course.
For reasons I'm not quite clear about, but you can no doubt explain, in the previous paragraph, Mr. Justice Kennedy is talking about a claim for contribution or indemnity. So you've got a situation where A is liable to B, but seeks an indemnity for the amount of his liability from A, or at least a contribution from C, on the basis that he was induced to do the action in question by C. How did that arise in this case?
I'd understood it to arise because he was suing the directors of the company for the indemnity. He wasn't.
Well, he agrees to take part in the Jameson Raid. Unknown to him, he was thereby committing an offence against the Foreign Enlistment Act 1870. So the defendants say you have no cause of action, and the court says that's outrageous. Of course he has a cause of action. But does that help us?
Well, it does, because the passage that I was going to refer to, it discusses the case in the context of an indemnity.
What do you mean by in the context of an indemnity? How is an indemnity, in the sense we're discussing in this case, even anything to do with the case? I'm not trying to make it difficult. I'm just trying to understand what he was really addressing.
I see that. I can do no better than to.
Why not just show us the passage that you intended, and we'll work out for ourselves in due course how it all fits in. What's the particular passage that you rely on?
Yes, I would. It starts on page 84. I accept that one of the defences.
Which passage is it? Sorry.
It's page 84. If one reads, and I think it's helpful to read that, on page 84, second full paragraph begins, "It has, I think, long been settled law." If one reads that paragraph over on the page, over that page, and then over onto the next page, one sees in my submission that the discussion is about an indemnity. For a start of it, starts to refer back to some of the cases.
Okay, well, let's just read that passage, and then you can make your submissions about it. Yes, thank you. I've read it.
Thank you, my lord. So the point is that is a discussion starting on page, notwithstanding what is said in the headnote, and notwithstanding what appears at Mr. Justice Kennedy is discussing this case as if it were an indemnity on page 84. And then at the bottom, the passage I was referring to earlier, he says, I think it's also clear that an action for an indemnity grounded either on deceit or warranty may be maintained where the party who seeks the indemnity has incurred damage by reason of his having been authorised or, as alleged in this action, fraudulently induced by another to do an act indifferent in itself, which has turned out because it constitutes a private wrong to be unlawful, but which was not at the time apparently unlawful. And then he refers to the cases, certainly Fletcher and Harcourt, Adamson and Jefferson. So I accept there are two scenarios he's dealing with in that sentence. He's saying, in this case, what's being sought is a result of being fraudulently induced by another to do this act. But he says, because he precedes that, as is alleged in this action, but before that he says, by reason of having been authorised to do an act indifferent in itself, which has turned out because it constitutes a private wrong to be unlawful. That is a description derived from the cases of Adamson and Jarvis, and, as he says, of express indemnity in Fletcher and Harcourt, of the implied indemnity. So, in my submission, clearly the judge is talking about, even if it's only by way of analogy, the situation where there's an implied indemnity of the type that we have been looking at. And
what court this is? What court is this?
I think it's the divisional court. There's
Thank
Mr.
you.
Justice Kennedy, and is there not another?
Justice Grantham.
Yes.
Yeah. Okay. Thank you.
And one in Mr. Justice Grantham's judgment at the top of 81, he also describes the course of action in terms of an indemnity. One sees that page 81 in the bundle, the first 6 lines. And he goes on, by the way, he then goes on.
Hang on, sorry. This case, the plaintiff is not seeking to recover an indemnity for damages recovered against him,
but
is seeking to recover damages for a wrong done to him.
Yes.
So why do you saying he's saying this is an indemnity case? He's saying it isn't an indemnity case.
Because when he goes on to discuss the authorities, those authorities are Adamson and Jarvis and so on. We see that below.
Yes, but that's because they raised the point about unlawfulness, don't they? But civil unlawfulness.
If one looks on the previous page, at page 80, it says, the main question is whether a person convicted of a criminal offence can claim indemnity from another who has participated with him in the commission of that offence. I was simply relying on that in support of what I said about Mr. Justice Kennedy. It's clear, as I said, from what Mr. Justice Kennedy said, particularly at 129, I now come to the question which was very fully argued before us in the present case, namely, does this right of indemnity, which exists in the case of a private wrong done by misadventure, exist also in any case in which the wrong is a criminal offence? So, as I said, whether it is by analogy or not, there's clearly an approach by the court here bearing in mind the concept of this indemnity in the sense of Adamson and Jarvis. That's all I'm trying to suggest. And the point I wanted to derive from that was simply this, that first of all, the claim is held not to be demurrable, so it wasn't struck out. And second of all, there's clearly in this, I say, a claim for loss of earnings. And if it was so obvious that that was not within the scope of the implied indemnity, which they do talk about, one might have thought that would have been struck out. There'd be no point in
But it wasn't a claim for implied indemnity, it was a claim for fraudulent misrepresentation. You fraudulently misrepresented me to take part in this venture in which I was wounded and suffered a loss of earnings. That was a perfectly conventional claim, isn't it? Whatever you may say about the analogy drawn by Mr. Justice Kennedy with cases of implied indemnity, when considering the point about the relevance that the enterprise was illegal, on the actual claim, the claim is it's not a claim for an indemnity at all. Well, we'll come back to that if you...
Yes, I'll think about that.
So is that all you want from boroughs and roads?
Yes. Can we now look in bundle A1, please, at tab 21? This ago. The facts are set out in the head note, and the important bit is towards the end of that head note. This is page 364 of the bundle, and it's in the right-hand column.
Which particular part?
Explaining about how the vessel was arrested at the suit of the shippers.
Which particular part?
Of the
column.
Oh,
you said look at the right-hand column, but I just want to know where to look at.
Yeah, I'm so sorry. It's the second. It's the first full.
It's the paragraph starting in the event.
Yes, and the paragraph above that.
Yeah, thank you.
Sorry, Mr. Toomey, which page?
It's page 364, tab 21, page 3, bundle page 364.
Are you going to make some submissions about this, Mr.
Yes.
Yes, please proceed.
Page 366, there are some sidelines which simply show that there was a claim for loss of earnings while the vessel was under arrest. One sees that from the
yes.
particulars of the amount of loss. And then if one turns on to page 374, there is a discussion, there's a heading there, left-hand column, about the right to indemnity.
Yep.
And there's a discussion, the sidelining is the bottom of that column, the rest of the right-hand column, over onto the the next page, halfway down the left-hand column.
Yes, so we can see that. What you want? You don't want us to read all of that, do you? I am.
No, it's not necessary to read all of that.
So which is the bit you'd like us to read?
The analysis of the earlier case of there's a quote from the earlier case of Strathbourne Steamship and Andrew Weir, and that appears on 374, right-hand column, about halfway down. Point being that what we're discussing here is Dugdale and Lovering is one of the, we haven't looked at it, but it's one of the earlier cases on the principle of implied indemnity. It's not an employment case. So what is in scope here is the implied indemnity. And one sees that Mr. Justice Staunton awarded the loss of earnings, or the loss that was incurred because the vessel was being held.
Against whom was loss of earnings? Was obviously the money that the ship would have made if it had been able to be sailing. Against, and that loss was suffered by the owners.
Yes.
Is that amount awarded direct? Who are the parties to the case?
The parties, as I understand it, were the owners and the charterers. So the indemnity is against the charterers. That's back at the head note,
yes.
Page 364. So the owners were claiming against the charterers. And
in indemnity, in what sense?
An indemnity, one sees from this part of the head note, an indemnity, there was, holding to, an express or implied right to indemnity arose because the owner's loss was a consequence of complying with the charterer's orders. And that arose because the charterers had given orders to the master, who's the agent of the owner, which he could have disobeyed, but one sees from the discussion we just looked at that it was perfectly reasonable of him to carry out those orders. In consequence of that, a loss is suffered, including the loss of earnings while the vessel was under arrest, and so the owners were entitled to recover from the charterers.
Is this an analogous situation to the one with which we're concerned in this case, though?
In my submission it is. I mean, the first point is that what this shows clearly is that in relation to an implied indemnity, it is possible to get loss which is akin to loss of earnings. The lost earnings, because you can't.
No, I see that. Obviously, I see that's the point you're making. I'm just wondering whether this is an indemnity in the same sense. I mean, maybe it is, but it's quite important to understand the relationships involved and the natures of the liabilities.
In my submission, it works like this: that the charterers were the ones in the position of giving instructions to, in effect, the owners. I appreciate it was they were giving instruction to the master, but he was the agent of the owners, so they are in effect giving instructions to the owner. The result of that is that there is a third-party intervention, namely the ship is arrested, and the owners are losing money because of that. And they say to the people who have given the instructions, the charterers, you've got to pay us for that. And Mr. Justice Staunton agreed. And that is analogous, as I see it, to the situation we're in.
Who's the third party in that relationship?
In that relationship, it's whoever the authorities were. Well, it would either...
There's no liability to the authorities.
No, there isn't. I'm not sure it's the authorities. It just says the vessel was arrested at the suit of the shippers.
Yeah.
So
what I was thinking of, page 375 of the bundle, in the left-hand column, there's a quotation from a case called Dugdale and Lovering, a statement of principle by Mr. Justice Brett. When an act has been done by the plaintiff under the express directions of the defendant, which occasions an injury to the rights of third persons, if such an act is not apparently illegal in itself, unhonestly and bona fide in compliance with the defendant's directions, he shall be bound to indemnify the plaintiff against the consequences thereof. Now, as I understand it, that's the indemnity principle which you invoke. Is that right?
yes,
Yeah. But there, the injury is caused to the third persons. And analytically, and please correct me if I've misunderstood this, analytically, I can well understand that if the injury caused to the third person includes loss of earnings, then of course, in principle, the indemnity clause will cover that. But whose loss of earnings are we talking about?
we're talking about the owners of the ship.
Yeah, but are they in my analysis, are they a third person?
No,
Or they're not?
no, the third person.
They're actually the person being indemnified, are they?
Yes,
Right.
they're not the third person. They're the person being indemnified by the
Isn't this an
client.
indemnity in a different sense, arising out of the relationships between owners and charterers? We have to be careful about this word indemnity, especially as anyway, it's not even a case where we're dealing with an express clause. But basically what's being said here is if the charterers give instructions to the master which lead to the owners losing money, it's a term of the contract between them that they must pay the owners back for their loss. Now you can call that an indemnity, but it's not the situation we're dealing with here.
Why not? The principle, Mr. Justice Staunton.
Relationship, isn't it? I mean, if someone's chartering a vessel, not an agency situation, not an employment situation.
Yes, but it's a request situation. It's a request situation because what the master does is at the request of the charterers. That's why it falls within the basic principle of the indemnity that we looked at this morning. It's a request situation. It's not brought about because of the contractual relationship between the charters and the owners. It's not some kind of implied, well, it is an implied term, but the rationale for it is the implied indemnity based on this idea of the request. We looked at in all of the cases this morning.
Yes, well, I see how you put it. I'm a bit concerned about time. We've been going very laboriously through these various authorities on the indemnity point. I don't know how much longer on the indemnity point you've still got to go, but we have still got duty of care and your challenge the judge's finding on the facts, which might go to both the narrower indemnity and to the duty of care. You're obviously master of your own submissions and how you develop them, but can I just flag that up, that we don't want to get too bogged down in all these authorities and not leave you with enough time for the other aspects of the case.
Yes.
But you carry on, but I just thought I'd flag that.
I appreciate that, my lord, and I do understand that, but I wanted to get to the end of these authorities. I've got one more to look at, and then I was going to look at Whitlam, which is quite important, and I had a few other submissions.
Don't go on explaining. Just carry on. Yes. So you want to take one more case?
Yes.
Which one is that?
It's the ENE costs, which we looked at.
Pretty briefly looked at. Yes. Remind me where that is.
Bundle A3, tab 44, page 693.
Yes, I have it.
I appreciate it's a case of an express indemnity. In my submission, the express indemnity here is in the same, more or less the same terms as some of the principles of authority. The principles we've looked at this morning. It was an indemnity against all consequences or liabilities that may arise. One sees that from the head note. The facts are...
Sorry, I can't quite hear you.
I said it's an express indemnity, but the terms of that follow follow the cases we looked at this morning when they talk about indemnity against...
Would it help us just to show us where the indemnity is?
Yes, well, I was just referring to the head note.
Yes, I've got it here.
My lord, it may be helpful to read the head note, but one sees the key wording
in the first sentence.
In the first sentence.
Okay. All consequences or liabilities that may arise. Yes. We have that. What's the point you're making next?
The point that I wanted to make next was twofold. First of all, that this is another case where there was in effect a loss of profit or loss of earnings, however one wants to put it, where that was awarded. And one sees that again from the head note in the middle. It says the owners brought proceedings inter alia for inter alia payment for the service of the vessel during those 2.64 days. That's the time it took to get the cargo off, and for bunkers consumed in the same period. And they brought the claim pursuant to the indemnity and pursuant to rights as a non-contractual bailee. I think they won on both grounds. But so the claim there for 2.64 days of the loss of the use of the vessel is in effect that's a claim which is akin to the claim we just looked at in the Sagona. It's a loss of earnings. They lost 2.64 days of earnings while the charterers, or the former charter parties, cargo was offloaded, and they were held to be entitled to that. And we looked this morning at the part of Lord Sumption's judgment when he said, well, that was an effective... The fact that their cargo was on the ship was an effective cause of this loss. But I wanted to just draw your Lordship's attention to paragraph 9 of the judgment, which deals with the analogy or the reason for the indemnity, and to suggest that is analogous to the situation of an employee. If one looks at paragraph 9, and it's quoting from Mr. Justice Devlin, it says, if the owner is to surrender his freedom of choice and put his master under the orders of the charterer, there is nothing unreasonable in stipulating for a complete indemnity in return. Pausing there. Lord Sumption says it's not just not unreasonable, it's necessary, and it will be implied even if it's not expressed. And the analogy I wanted to draw was this, that an employee also gives up, they surrender their freedom of choice, and they place themselves under the orders of their employer. That's the whole point of an employment contract. And there's nothing therefore unreasonable in expecting a complete indemnity in return. So there is an analogy to the employment situation. Before we leave this, there's just one final point. Paragraph 11 at page 973, letter C, Lord Sumption says the purpose of the indemnity is to protect them against losses arising from risks or costs which they have not expressly or implicitly agreed in the charter party to bear. And that is relevant. That rationale applies equally in the employment situation, and it's relevant to the issue of whether or not it matters that the events that engage the indemnity are foreseeable or not. That's really it on those cases.
Thank you.
I was then going to move on. In fact, we can leave bundle A3 open. Actually, I wanted to make one last point before we leave that case. But it's
Sorry, yeah.
If one accepts the analogy that I seek to draw, then and sort of thinks about the employment relationship from a commercial perspective, it's particularly stark in the case of Mr. Benyatov, because of course he's an individual and the bank is a multi-billion-dollar institution. But if one thought, well, who's bearing the risk of something going wrong, the answer in my submission is it makes common sense and commercial sense that the party which is giving the instruction, which is going to gain from the instruction, takes that risk and not the individual employee. And it would be bizarre in my submission if the owners of ships like the Sigona were in a better position than employees like Mr. Benyatov. Turning to the Whitlam case, we saw this morning, and we need not turn to the precise paragraph, but we looked this morning at paragraph 320 of the judgment, where the judge had, as it were, two reasons for his conclusion why the indemnity didn't go further than the position contended for by the respondent. One was, he said there's no authority, and two, he relied on particularly paragraph 94 of the Whitlam case. So it's clearly central to his decision. Before we turn, it may be helpful to just look at the way he reasons it before we actually look at Whitlam. It's in the core bundle, tab 7 at page 178. he starts there at paragraph 320. He recites paragraph 94. We're going to look at that in a moment. I'm just explaining that this is the beginning of his reasoning. So he starts off by looking at paragraph 94 of Whitlam. And then he says, records the bank's submission, 321. In his discussion at paragraph 322 over the page at 179, he says this: the decision in Whitlam is more controversial than is recognised by the bank's submissions. And then he explains towards the end of that paragraph, it starts, the controversial aspect was that the case appears to be on all fours with Famatina, where costs incurred in defending proceedings were awarded pursuant to the indemnity. In Whitlam, the costs incurred in prosecuting legal proceedings made to clear Mr. Whitlam's name consequent on a publication made in the course of his employment. And then what he does, and I'll seek to do this without turning back to the Famatina, is to record why the deputy judge thought that, in effect, if an English court were looking at the Whitlam facts, they might have reached a different conclusion. And that is seen in paragraph 323. There's a quote from 141 of the deputy judge's case, where he explains that, and he accepts as set out in a legal article, Famatina is actually an extension to the formulation of the principle in Sheffield Corporation and Barclay.
Incidentally, we haven't been given a copy of that article. No idea whether it's relevant or not, but title suggests it might be. You have copies, presumably.
We can get copies, yes, my lord.
Well, I wouldn't mind seeing one. I speak for myself. So if you could get copies for us overnight.
Yes, my lord.
Yep. And I'm assuming, by the way, that apart from what you've referred us to, there's no academic discussion of this question of the indemnity. I've looked in Harvey, there's almost nothing there. I've looked in Friedland on a contract of employment, I found nothing there. But you've done that sort of research, presumably.
Yes.
And it's virgin territory.
Yes, and without disrespecting the authors of this article, one of them was counsel in that.
Well, I dare say, but yes.
What I was about to say was there are a number of cases that aren't cited in there, and in fact the deputy judge lists them. So
yes, I dare say when we see it, we won't find it. But in a case where we're deciding potentially a big point, one just needs to be comfortable that the academic literature has been searched and anything relevant has been drawn to our attention. But I assume you've done that.
Yes.
Okay, well, you may well be right. This isn't any use to us when we see it, but I wouldn't mind seeing it.
Yes.
Okay.
Well, if we're going to talk about the academic literature, there is a book, but it's basically somebody's PhD thesis, and it doesn't really. It discusses some of the cases we've looked at. It's also it's somebody's PhD thesis, so it's massive and not very digestible. So we haven't.
Well, if neither party wants to refer us to it, so be it. I wouldn't mind knowing what the name of it is, but I promise not to decide the case on either party on the basis of a point which appears only in the book. But
it's called. I think it's called Contractual Indemnities. It's by someone called.
Well, if your junior could send us the reference after the hearing, we'll decide whether to look at it. But yes. We promise, as I say, not to decide the case on the basis of a point that's only there.
Yes.
Keep going anyway.
Yes. It's not exactly bedtime reading, is all I can say. It's pretty hard.
You don't know what I like reading in bed.
Right. So, without turning back to Famatina, the deputy judge thought that the New South Wales Court of Appeal hadn't appreciated the real effect of the Famatina. We see at the end of paragraph 324 the trial judge adopts that analysis, but he says he doesn't really need to answer it, and that's because he's going to go. He's really focusing on paragraph 94 of Whitlam. All of this is just to explain the context of what I'm about to say and the way that the trial judge dealt with the case. And he draws that together at 326 as we saw this morning. So next, what I'd like to do is to turn to Whitlam and look at that. That's in bundle A3. Tab 40. The judgment starts at 879. The easiest way to understand the facts is, I'm not quite sure how these are set out, but if one looks on page 882.
Well, again, I think I speak for all of us. We have had a look at this case beforehand. We knew it was central, but that doesn't. So it means you take it shorter, but you still need to give us the key points. Yep.
Of course. I can take it fairly shortly. So the facts are paragraphs 2, 3, and 4. What had happened was Mr. Whitlam had given an interview, and as a result of that interview, he felt he had been defamed by 2GB and Channel 9. It was about his work for NRMA, and he had brought proceedings for defamation against those organisations, and then he sought an indemnity from the NRMA for his costs of bringing the defamation proceedings against those two parties. And first of all, it was there was an express indemnity. I think there were two deeds, and there was an express indemnity. We can whiz on because his claim under the express indemnity failed, and then there is one sees that for your lordship's note, paragraphs 50 to 52, page 893. But the discussion there is then a discussion of the question of an indemnity implied under the general law, and that starts at page 899, paragraph 83, and that was his alternative claim. And then there is some recitation of authority. Some of the authorities we've looked at this morning, by no means all of them. And 86 is where 86 and 89, where the court deals with the issue that arose in Famatina, and certainly in the view of Judge Tahar and trial judge, the problem with that analysis is it doesn't take account of the fact that in the Famatina, in fact, there was no injury to the rights of a third party. But we move on because that's not really the important part. If we go on now to 92, 93, and 94, this is Campbell J.A. He says, it will be seen, paragraph 92, that the statement of principle is dependent upon the bringing of proceedings against the company being part of the due performance of the director's office. In the present case, it was no part of Mr. Whitlam's performance of his office to bring the defamation proceedings. So whoever is right about the scope of the indemnity in this case, that, as it were, would kill it because the New South Wales Court of Appeal is saying it wasn't part of his duties to do this. That's, as it were, the end of the matter. But not our case. 93, Mr. Gleeson, who was counsel for Mr. Whitlam and the person that wrote the article, my lord, submits that while the case law so far has all been concerned with the situation where an indemnity applies to a legal liability incurred to a third person or to an action taken in the actual performance of an office, he says there are no reasons to think that the operation of the general principle should be limited to that narrow class of loss. And then at 94, Campbell J.A. explains his concern with that broad suggestion.
Well, we've all read this paragraph already. You don't need to read it out, do you?
No,
I wasn't. What do you want to say about it?
Yes, what I was going to say was this. It's clear that Campbell J.A. accepted that the implied indemnity covered losses suffered by the office holder in consequence of the performance of his or her duties. And that's really our case. At 93, he's going on to consider the wider suggestion of Mr. Gleeson. And it's against that background that he makes his comments at paragraph 94. And what we say about that is that his concerns are really overstated for the following reasons. First of all, it doesn't really address the situation where there's a third-party interaction. The example that he gives in paragraph 94 is there's no third-party C. He just talks about A requesting B to do a task in the course of which B is injured. And there's no suggestion of an interaction with a third party. And as I've suggested, if you look at all of the cases, there is an interaction with a third party.
Why does that make a difference in your favour?
Well, because in our case, there is an interaction with the third party.
Yes, but why does the fact that there's an interaction with a third party make a difference? He gives the example of personal injury. Suppose the personal injury had been caused by a third party, maybe a fellow worker.
Well, then, that's really where I was going to go to
I see.
next.
Okay,
yes,
I haven't got it yet.
that
but I
isn't
will
what
when
he's
you get to the
talking
end.
about. But if there were a third party involved, then our answer to that is, well, then there might be parallel claims in tort and under the indemnity. What I was trying to say was, on the situation that he's putting forward, he's sort of created a situation in tort and then said, well, the indemnity doesn't work for that. And what I'm saying is the indemnity works where there is a third-party interaction. I accept that may nevertheless mean that there would be two potential causes of action.
Well, you say they would be in parallel. In the real world, nobody would ever sue their employer for negligence if they could sue under the indemnity clause where they don't have to prove negligence. Because I think you said earlier to me today that if the indemnity applies, it's an absolute guarantee. And you don't have to show fault on the part of the employer. Is that right?
Yes, my lord.
But now, if that is right, isn't the fundamental point of legal principle which Campbell J.A. is making at paragraph 94, that if indemnities really do have that consequence, that would cut right across the law of negligence. And it would be surprising, therefore, that we've never seen a case like that in the book so far.
Well, that is the point he's making. I see that, and I'm seeking to answer it. It may not be.
Sorry, can you speak up a little?
I accept that that's the point he's making there. What I'm saying is that, first of all, the indemnity is limited to cases where there is a third-party interaction. Second of all, I've lost my thread. I was going to say, yes, I was going to talk about the direct relationship between the requirement for loss and the task and the instruction given to the employee. And I appreciate that they were not necessarily accepted as limitations, but the other requirements which are required to establish liability under the indemnity. But so it's not as, what I'm trying to say is, it's not as broad as Campbell suggests here. I do accept that there may be some cutting across the law of tort, but the answer to that, we say, is that is not necessarily fatal, and we rely on two cases in relation to that. One is the case we looked at this morning, and that was the Birmingham and LNWR case. That was the case of we looked at the judgment of Lord Justice Fry. I'm not going to go back to that. That was at A1, tab 10, page 69, where in my submission, properly understood, what he was saying was, look, you can have a claim for damages, or you could have a claim for indemnity. He's not saying you have to have one or the other. You could have both. And in fact, he was saying the measure of damages for them might be the same. And the other authority that we rely on is the Spring and Guardian case, which is in bundle A2.
Sorry, but before we go on to Spring and Guardian, which is about giving of references, can we just stick to the Justice Campbell's paragraph 94 and the question about basic law of tort, personal injury. There are various possible systems for compensating people for accidents in the course of their employment. In our system, the claimant has to show breach of statutory duty or negligence. In the New South Wales system, there is workers' compensation on, I think, a no-fault basis, but it's more limited than common law damages. And it's often suggested we should have a system here, such a system here, but we don't, with a few exceptions. But what the judge is saying is that if there is a right to an indemnity, then that would make all these distinctions immaterial, because the claimant just says, I want full common law compensation under the indemnity. Then if you move outside the workplace, where the employer may be under some direct duties, you have cases like, is it Reed and Russian Tompkins, which is cited somewhere in the bundle. The employee is driving a car on company business, but abroad somewhere. a third party crashes into him. The employee wasn't doing anything wrong. Is he entitled to an indemnity from his employer for the fact that he was going about company business perfectly lawfully and some idiot crashes into him and causes him injury? No, said the Court of Appeal. Now, how do you distinguish that sort of situation?
I distinguish it as follows, that in the Reid case, the performance of his duties was the occasion for what happened to him. It wasn't the direct cause. It didn't happen to him. It comes back to the distinction I was seeking to make this morning, that it was the occasion for him happening, for what happened to him. It wasn't the direct cause of it. It was the cause of it in a but-for sense, I accept that. But what we saw in the E&E costs this morning was Lord Sumption saying but-for isn't good enough. That's really saying it was that's the equivalent to saying, that's what the occasion for means. It means but for the fact that he'd been told to go to, I can't remember which country it was, he wouldn't have had an accident, or but for the fact that I just asked you to go to that building which collapsed, he wouldn't have had an accident. That's
what about
different.
but for the fact I wasn't asked you to work on this, that I'd asked you to work on this transaction, you wouldn't have been prosecuted by the Romanians?
Yes, but it goes much further than that, because the basis of the prosecution was what Mr. Benyatov was doing. That was his. The prosecution consisted of nothing more than a recitation of what his job was, and that of his team. That's what I said this morning when I was trying to explain that the evidence, insofar as Mr. Benyatov was allowed to see the evidence, was basically consisted of transcripts of call intercepts, of telephone and other surveillance of him and his team going about their work. But that's in a different situation. That's not just a but-for analysis. That what happened to him, the very basis of what happened to him, was the work that he did. That is not the same as saying as a but-for analysis. My Lord Singh's example this morning was a very good example of the other side of the dividing line. If the employee is given a direct instruction to break the speed limit in order to get the package delivered, and then gets convicted of breaking the speed limit, the very cause of the conviction is in effect the instruction given to the employee.
Yeah, okay, well, that's helpful. Then that's your answer to Reid and Rush and Tompkins. My Lord was making a broader point in any event about a general indemnity undercutting any system of worker compensation, whether based on fault or based on a statutory scheme. Neither would be necessary. You just say, I suffered this when doing the work. I mean, I think your answer is really, but goes back to the points you made when similar made in the course this morning. You said there were several limitations. It was quite a narrow right when properly understood.
Yes,
that's really the points you deploy again here.
It is, and that's why there aren't that many cases even of the indemnity. Never mind any suggestion of undercutting. There really aren't a huge number of cases in the indemnity, because to actually get it to work, the cases all end up being rather unusual. And I just don't accept that it would, or that the mere existence of it would undercut. It may be that people would seek to enforce that right, but there are different requirements. This is a point that's made in Spring and Guardian Insurance. Where you have different causes of action, there are often different requirements in relation to them, and you claim might succeed on one and fail on the other. If there's a clearly established I was going to say this, perhaps, in relation to injury at work cases, obviously the reported cases concern edge cases, but for most people bringing claims in relation to injury at work, there's a perfectly good set of workable law that makes it very easy to determine who's at fault and when people should be compensated. So why do you need to go further than that? There's an existing remedy that works very well, so why would you start looking around for alternative legal remedies? I was going to move on.
You were going to take the Spring and Guardian.
I was going to go to Spring and Guardian. That's in bundle A2, tab 28, page 608.
This is a case, as my lord reminded us, about duty of care in giving a reference. We're all broadly familiar with it, so what's the particular passage that's relevant?
Well, I won't trouble your lordship with the head note, but before we get to the point in relation to tortious liability, it's worth just noticing that while we're here, at page 648 in the bundle, at the top of the page, letter A, it's just interesting to note that the first instance, and the House of Lords didn't depart from this, it was accepted that because of the nature of the regulated professional financial services environment that Mr. Spring worked, in the absence of a proper reference, that was described as the kiss of death to his career in insurance. And then the suggestion of the overlapping potential. The suggestion was made that there would be an overlap with
defamation.
Yes, defamation, my lord. That is dealt with at the bottom of 629, page 617G.
Is all you're citing this for the proposition that you can sometimes have overlapping courses of action?
In effect,
but,
yes.
Well, I mean, if your time is limited,
I agree.
Right, that's that. Before I leave them, I just wanted to make one other point, and that is that we say if there is any cutting across, then in fact, except it might be to a limited extent because it wouldn't include loss of earnings, but if there is any cutting across, it already occurs as a matter of fact. If on your claim for damages under a tortious duty of care, you wanted, for example, to claim legal expenses or some other kind of expenditure, you could also, it's open to you if you want to claim that money under the indemnity. But so, in a sense, even if the indemnity exists in that limited form, in a sense it already cuts across, if that's the way that one wants to see it, the duty of care in tort. And the final point in relation to the Whitlam case is to think about the narrower, or the indemnity rather, as formulated in paragraph 19.2 of the amended particulars of claim, which deal with the circumstance where the indemnity is not lost because you innocently take part in something which turns out to be unlawful. That is a much narrower set of circumstances in which the indemnity operates. And why in that state, if there were any cutting across, and it's not clear that there would be, why would it not be correct as a matter of principle for the indemnity to operate, at least in those limited circumstances, even if you could construct a claim in tort? What I'm going to do, I think, is to move on to ground 5 and deal with this as quickly as I can do. Before we leave ground 4, we say that if you look at the underlying rationale.
Sorry, you're moving to ground 5, or was this
Yes.
the last point on ground 4?
Yeah, I'm going to deal with the last point in ground 4.
Yes, okay.
Forgive me.
Sorry, I missed the beginning of it. If you look at the rationale, yep.
Yes. The underlying rationale, we say, is that if the requested party suffers damage as a result of doing the requested thing, this is at its most basic level, it is only just that the party on whose instruction they acted should hold them harmless from the consequences. Those are the very old statements of principle. Now, if one accepts that there is an implied indemnity, which is what the judge found and was accepted to a certain degree by the respondents, then you're accepting that on the basis of accepting the rationale, I would say. And then why is it just to place a limit on the remedy available to the party? We say that's inconsistent with the underlying principle. And if one doesn't accept that, I say, well, at least you should be very wary of concluding that in every case the limitation contended for by the respondents operates to limit what's available to protect the indemnified party. I'm now going to move to ground 5 for certain, and that is dealt with in the judgment at paragraph 365, bundle C, tab 7, page 189. Heading there, indemnity in fact.
Yes.
I'm just thinking, my lord, because I was wondering if I can avoid turning to an authority. What we say is this, that the implied indemnity, subject to the limitations proposed by the respondent, had been admitted, and the judge had found that there was such an implied indemnity. And here, what in my submission he was meant to be considering was whether, never mind the position at law, in fact, there was a slightly or a wider indemnity implied in this case, which extended to being able to recover Mr. Benyatov's loss of earnings. He sets out the relevant legal test, and this is for your lordship's note, at paragraph 359 of his judgment, and refers to the Marks and Spencer case.
Sorry, are we at cross purposes? J359? No reference to Marks and Spencer there.
Ah, right, it's my... If one looks in the first sentence, it says, as an alternative argument for Mr. Benyatov is that there can be an indemnity in fact, which, as seen from the extract from Chitty cited above, is implied into a particular contract in order to give...
Yes, but there's no reference to Marks and Spencer.
No, but if one turns back to... 305, paragraph 305 at page 370. That, as far as I can tell, is the passage that the judge is referring to here.
Yes, I see. Okay, hang on 1 second. Yes, I see. But
all I was going to say, my lord, was that I accept that as the test for implication, but
what is, sorry, the reference to being necessary to give business efficacy to the contract also obviously goes without saying.
That's problematic. What I was going to say was I accept that the Marks and Spencer case contains the test for implication. This, whilst there's a quote from Chitty here, there isn't a quotation from the Marks and Spencer case, and I thought...
I've got in a muddle here. Does it really matter? Surely, I don't think you're being quite fair to what the judge was saying there, but he must have been applying the test, mustn't he? The usual contractual tests of, I'd frankly forgotten they were mentioned in Marks and Spencer, but they're the time-honoured ones. If it's not a scally type one, and therefore has to be particular to the particular contract, it's got to be either necessary to give business efficacy, or so obvious it goes without saying. That's time-honoured stuff, isn't it?
It is, and that's what he should have been doing.
Isn't that what he was doing?
Well, I say, no, he wasn't.
Well, that's what he expressly says in paragraph 305, just above the reference to Marks. He refers to scally, he refers to business efficacy, and he refers to so obvious it goes without saying. But you say that later on he applied the wrong test.
Yes.
But are you saying that simply because he refers to the extract from Chitty rather than the Marks and Spencer principles?
No, I'm saying that, and I apologise, I'm not making myself very clear. I'm saying that because when you start to see his analysis of the indemnity in fact over the page 190, paragraphs 362 and 365, he doesn't seem to be implying the test for implication that he mentioned earlier.
Well, we see he does mention it. He alludes to it halfway through 365. An implied term, in fact, is very limited bearing in mind the test for an implication in Marks and Spencer. And that's right, because both the business efficacy test and the what I'll call the officious bystander test pose quite a high bar. That's clearly what he says he's doing. Now you may say when he goes on to do it, you can see he isn't doing it really. But if you're looking for an explicit misdirection, I don't see one.
Sorry, my lord, but I do. It's very difficult to follow. If one looks at, let's just go through this. At 359, he refers back to his extract from Chitty.
Yes, but you said that wasn't the problem.
No. He then starts talking about Spring and Guardian Assurance. Not clear why, because we're now talking about indemnity in fact. At 360, it doesn't...
Well, let me just see. If you're troubling, if that's a real point, I must just see what he is saying. Okay.
So
it seems to me, and correct this if I'm wrong, in fairness to the judge, he's actually making a point in your favour there. He's carefully directing himself that just because something might not be within the duty of care, that wouldn't not necessarily mean that you can't succeed on indemnity. So that's why he's making a reference to Spring and Guardian, that you have to be careful. You can have overlapping causes of action.
Yes, my lord.
Right. So far, so good, it seems.
Yes. I wanted to come back to this, but at 361, he picks some of the points which were said to give rise to the implication. By no means all of them, but he's picked some of them. I accept that, not all of them. And then at 362, he says, at the heart of these points is a case that the risk profile of Mr. Benyatov in Romania, as regards the country and or transactions in which he was involved, was high risk, such that there should be a broader indemnity in fact than the indemnity in law. That's just not a correct characterization of Mr. Benyatov's case. And then he goes on to say, the case for an indemnity in fact could not sensibly be determined by the contract being one of employment or agency or relational. Now, the reason he's saying that is that although he hasn't listed it at 361, we did rely on the fact that it was an employment or a relational contract. So he's simply saying, well, that doesn't get you home. That on its own is not good enough. That's fine. He says that does no more than give rise to an indemnity in law. The critical additional factors relate to the high risk elements. That's just wrong, and I'll take you to the pleading in a moment.
Okay, I'm sorry. You can by all means, but I've got lost where we're going. I thought you had started by making a submission to us that he had not directed himself correctly as to the tests for the implication of an implied indemnity in fact, as we're calling it. is that still your point, or are you simply saying that he applied it wrongly? That ostensibly he directed himself correctly, but then he got it wrong when he sat down to apply it?
It's the latter, my lord.
Right.
I wanted to go to Marks and Spencer's to show that he refers to it, but what he doesn't do is set out the questions in that authority. But the real gravamen of my complaint is that he's misapplying, even if he had understood Marks and Spencer's correctly, he's misapplying the law here, because we see this in the next sentence. He's mischaracterized the case, but then he says, these factors have not been established, as is apparent from the findings in connection with the negligence. So he says, his reasoning in my submission is this. We're looking at whether there's an implied term. As far as I'm concerned, the implied term is all about whether it was, what's in favour of the implied term? Well, not the fact that it's a relational or an employment contract. That's not good enough. As far as I'm concerned, he says, it's about the fact that Mr. Benyatov was doing high-risk work in Romania. And then he says, in effect on that basis, these factors have not been established, as is apparent from the findings in connection with the negligence. In other words, he's saying, and we see this when we look at 365, he's saying, implication, I don't need to worry about implication, because the implication would have been based on factors which I have found did not apply in this case. That is what that sentence means. And
why is that wrong?
Because that's not that's it's a mischaracterization of the evidence, but it's not asking it's just not asking any of the questions in that Marks and Spencer's require.
Well, is it? Why, surely it is. You could say it's too obvious. Let's stay on the so-called officious bystander first. Too obvious to need saying. Your case would have to be ex hypothesi. I've lost on whether there's a general indemnity, but in the special circumstances of the particular circumstances of this case, there is a general indemnity because it's too obvious to need saying that if you put me into this high-risk situation where you should have been apparent this is just the sort of thing that might happen dealing with these people in these circumstances, if you ask the officious bystander, well, if it all goes wrong and he ends up being prosecuted, will you pay him all the... surely you need to spell out that... sorry, I'll start again, making a schoolboy error here. If the officious bystander says, well, surely there needs to be a term in the contract that in these particular circumstances, if he ends up being convicted by the Romanian court, you'll pay him career-long losses. Both parties would turn to him and say, absurd. I mean, of course we don't need to say that's too obvious to need saying. So wasn't that the nature of the case? It had to be the nature of the case. And if he finds, well, there aren't circumstances that are that high, then that's an answer to the too obvious to need saying case. I didn't do that very well, Mr. Jume, but I hope you saw the point I was making.
I saw it.
So why do you say that focusing on the high-risk factors isn't focusing on an essential point in the too obvious to need saying alternative? And the same would really go for business efficacy. You say, well, this contract will never work unless Mr. Benyatov is given that kind of full indemnity. And again, if that's going to be arguable at all, it's only arguable at all on the basis that this is a particularly high-risk situation you're putting him into.
I understand the point, my lord, and it would be correct if it were an accurate description of what the judge had done in this case. We haven't...
Okay, but I just want to make sure what your real point is. You've said at various points he's mischaracterised your case. You haven't told us how yet, but we'll come back to it. But the point you were on at the moment was a different point. It was saying he's not asked himself the Marks and Spencer questions.
Yes.
And what I was trying to put to you then, rather long-windedly, was that actually the question he addresses there is at the heart of the Marks and Spencer questions. They won't go anywhere unless this was a particularly high-risk situation. So it's unfair to say he didn't ask himself that question, or he asked himself the wrong question. You can say I'm wrong, but you need to explain why.
Yes, I'm formulating an answer.
Sorry.
The problem is that in my submission, the approaches are different. I just need to open. May I do this for one moment before I
Yes,
give
of course.
an answer
Take your time.
to my lord? The problem, as I see it with that analysis, is this, and it's quite complicated to explain, but I will try and make it as clear as possible. It is true that in looking at the duty of care, the focus was on Romania, and there were a number of points made in support of the duty of care. One is that Romania was said to be a high-risk environment. The judge found against us on that. Problem with that finding is, of course, it's not a no-risk environment. It may not be high risk, but it's not zero risk. Secondly, he persuaded himself that a very important feature of the claimant's case in relation to the duty of care, namely the fact that whether or not Romania was high risk, there came a point in time when there were warning flags which should have caused a risk assessment to take place, and that was an essential part of the claim in relation to the duty of care. He found against us on that point, but none of that has got anything to do with the basis on which we say that the implied term in fact was to be implied. The points that we relied on in the pleading, a couple of them mention Romania, but most of them don't. They refer to other circumstances of the contract of employment. I'm going to go there in 1 minute. The other point is that the question that the judge was focused on in relation to the duty of care was whether the harm to Mr. Benyatov was reasonably foreseeable at some point in time. That is not the same question that the notional reasonable people are dealing with when they are facing a hypothetical question such as your lordship posed. What happens if for some reason the employee loses his FCA authorization as a result of carrying out his work for the bank? Will the bank compensate him for his loss of earnings? They were two different things. I said that I would go to the parts of the pleading, and I will do that briefly now. In the core bundle, at it's tab 12, page 259, we set out a non-exclusive list of the points that the facts and matters we relied on in relation to whether, as a matter of fact, the implied term, the implied indemnity should be implied. And one sees that in paragraph 25. Now, I appreciate that the judge referred to some of them, but his characterization that it was really all about whether Romania was high risk is just wrong. 25.1 and 25.2 are, it's a relational contract and a contract of employment. Well, he did refer to that, and he said that wasn't enough. But then we look at a number of the other points. These are factors, we say, in relation to the implied term in fact, would have assisted the notional reasonable parties in answering the hypothetical question. 25.7, clause 8, the contract provided that Mr. Benyatov may be required to work overseas. 25.8, not with reference to Romania, but it is obvious from the contractual documents that the defendant is a global company operating in all kinds of places around the world that present risks to its employees. That's set out in its regulatory findings. 25.9, 25.10, again drawn from the Credit Suisse group filings. The defendant, or the Credit Suisse, has a massive risk assessment machinery, as it might be expected for a bank. And these are factors that we relied upon in relation to why the notional bystander...
But there's no need to deploy that unless it's a high-risk country on the judge's findings. Anyway, this isn't about... You're slipping over into the duty of care arguments. Surely, if there is to be an implied indemnity of the kind you're relying on here, the question is whether there is an implied indemnity that would cover what actually happened in this case, namely in Romania. So it's quite right for the judge to focus on Romania. In fact, it might also apply to some other countries. Is irrelevant, isn't it?
It's not, because 25.14, at the time that the contract was made, which is when obviously the implication has to be determined in relation to, it was understood between the parties that Mr. Benyatov would be working not just in Romania, but place a number of Soviet bloc countries. He had a portfolio of 30 countries, including
but so what? I mean,
Russia.
So I don't want to be rude about any, let's just take one out of Tintin. Suppose it was Sildavia. And Sildavia was very high risk, even more high risk than Romania, and certainly no one should be sent to Sildavia without a risk assessment. That wouldn't assist on whether there was an indemnity covering what happened if he went to Romania.
It would, because the term that we pleaded doesn't mention the word Romania in it at all. We pleaded an implied indemnity, but if, to remind myself of the terms, if the things happened either in 19.1 or alternatively in 19.2, he would be indemnified. So it's wrong to focus on Romania. The factual...
But you're focusing on Romania here. These are the points on which you're relying, aren't they? Well, how's this topped and tailed? 25. Facts and matters giving rise to implication of the terms referred to in paragraphs 19.1, 19.2 include the following. You said that was non-exhaustive, but you can't rely on any that isn't pleaded. And they are all...
If my Lord will forgive me.
Yes, sir.
And it pleads, and giving rise to the duties at paragraph 24 above. So the structure of the case as put is that this is going to 2 points. One is the implied indemnities at paragraph 19, but the other is the duty of care at paragraph 24. So, if I may respectfully say so, you had chosen to plead the case that the same facts go to both issues. So it's not entirely surprising that the judge then says, well, because the facts on the duty of care haven't been made out in my judgment, they haven't been made out on the implied term either.
I see that, my lord, but the point is, he's focused on only on the facts in relation to the duty of care. It's perfectly possible, I would suggest, that there could be facts which are more relevant to the contractual term than compared to the duty of care. The duty of care, I accept, is all about the situation in Romania, but the contractual implied term doesn't mention Romania. It's about these potential to be indemnified if these bad things happen, and therefore I see what your lordship says, but the problem.
Nor does the duty of care mention Romania. 24, the core duty of care is a duty of care not to expose him to criminal conviction in the performance of his duties.
Yes, but if one looks at 24.2, and this is an important.
Yes, but those are just particularizations of how it applied in this case, aren't they?
Well, they are, but at 24.2, one is talking about whether or not the duty of care arose because of what were described as the warning flags, and that is just not relevant to the implication of a contractual term.
Yes, anyway, we take your point that the judge in his reasoning focused on what I might call Romanian risk, and not all, that doesn't cover all the points pleaded in paragraph 25 by way of particulars, although I'm bound to say it seems to cover most of them, of the matters relied on as giving rise to the duty. That's the point. And therefore the judge misdirected himself, or not misdirected himself, but failed to take into account relevant factors.
Yes, it goes further than that. At 363, there is a relevant factor which is completely misunderstood. He refers to the evidence of Mr. Matsukeli about
okay, have we with the point based on the plea, we can put the pleading away now. We're moving to a different point, is that right? I just want to get the structure of this right in my head. You've made a point which we've got and see exactly how it works about him not having looked at all the factors that he should have done when answering the Marks and Spencer's test. Now you're making one or perhaps more particular points about mistakes he made in the facts or the evidence. Is that right?
It is, but before we leave the pleading, there's a paragraph 2516.
Sorry, I put it away. Give me a second while I find it again.
It's
page
261, so it's core tab 12, page 261.
Yeah, and it's
2516.
yes.
It's not in terms of Romania. It's a general point about Mr. Benyatov's work, and we see that
25. Well, hang on, 2516. The said risks included the risk of being subjected to politically or commercially motivated judicial action. The said risks are which risks? Is it a risk? Is it a reference to high risk transaction in 2515?
It's a reference, I think, to 14 and 15. But those, I accept there's a reference in.
But that then is both of those are what you describe as former Soviet bloc. I'm not actually sure Romania was ever in the Soviet bloc, but that's doesn't matter too much. Not sure President Ceausescu would have taken that view. Don't worry, I'm just teasing you, Mr. Jimmy. I see the point.
Well, your Lordship is right, but the way it's written is emerging market countries of the former Soviet bloc in Eastern and Southeastern Europe, including Romania. So it's a reference to all of the countries in the bloc, which it was understood at the time of entry into the contract, Mr. Benyatov would be covering. As I said, he covered 30 countries. If one then turns to page 190 in the judgment at 363, Mr. Mazzucchelli gave evidence about how in 2004, 2005, so that's at the time of the formation of the contract, which was in April 2005, the bank realised the political environment in Russia was turning hostile towards UCOS, and so dropped its mandate with UCOS in the energy sector. So in that case, admittedly that involved Russia, but the bank took action in part to protect itself, but no doubt to protect its employees. And the judge says in such a case, the bank had exposed an employee to a high risk of conviction and loss of earnings, and the court might consider whether the indemnity might extend to loss of earnings. But, and I may have misunderstood this, but this is quite important because this is part of the factual circumstances at the time of entry into the contract. There had in fact been an issue whereby the bank had withdrawn from a transaction. And the judge seems to be saying that it is a factor in support of whether or not the implied indemnity goes that far. But he just leaves it there. It's a really important factor in support of an indemnity. He then goes on at 365 to say it is not necessary to consider whether the scope of an implied indemnity in fact could extend to loss of earnings in an appropriate case. And he says at the end of that, in the event the court...
Well, hang on, you need to read the next sentence.
Yes, that's a...
But why is that not a sensible thing to say?
Well, it comes back to the point that I've just made, that he has looked at a subset of the facts, and on the basis...
But he's looked at the relevant subset, which is the ones relating to Romania, which is where...
But that's just... I'm sorry, my lord, that's just not right. The relevant facts in relation to the implication of the contractual term come back to the question that would be asked of the reasonable bystander. And if the reasonable bystander knew that, never mind Romania, your job would be to go to Russia, and the
Excuse me, you're falling into the same trap as I momentarily did. It's not just what the reasonable bystander would think. The role of the reasonable bystander is to ask the parties the question, surely you need to spell this out. And they say, no need, it's too obvious to need saying.
Forgive me. If the reasonable bystander had said, look, parties, you, the bank, have all this risk assessment machinery. You, the bank, have had a situation just recently, because we're in 2005, whereby you decided to pull out of at least one transaction in Russia because you didn't like the political environment. And you, Mr. Benyatov, you'll be going to places like that and carrying out our work. That's the background. And then the reasonable bystander says, you, the parties, what happens in the hypothetical situation that something goes bad either in Russia or somewhere else, and Mr. Benyatov ends up getting damaged? Who's compensating him for that? And you don't answer that question by doing what the judge did, which was to focus very much on his very detailed findings about risk in Romania. That doesn't, it may go some, it just doesn't answer the point. It doesn't answer
Is this what you're saying? That if there's a term at all, the term will be expressed in general terms. And in deciding what term in general terms will you look at all the work which he might have had to do. So because he might have had to do work more risky than work in Romania, it would have been right to imply a term saying that if you get criminally if you're the victim of a conviction abroad, we'll compensate you for all your losses.
Absolutely, my lord.
Does that make sense? Because if the only possible answer to that is what it is because of the fact that there are some even riskier countries than Romania in there, surely the term would only relate to those countries. Let's just take, for the sake of argument, that your point that it would be necessary to imply a term that if we do business in Russia, you'll be compensated for all the losses that you may suffer if false criminal proceedings are made against you. Then you should have a term about Russia. But that wouldn't mean that you'd have such a term about Switzerland.
No, but I see that if one wanted to approach it on the basis of the term only being applied in relation to specific countries. But my point is that that wasn't what we were contending for.
No, but it may be that maybe in a sense it's the only thing you could reasonably contend for it is quite a frightening term for a bank to enter into. You should be contending for it for countries where there is a really serious risk only, and not then sweep up in it all the other countries where there isn't such a risk, as the judge found there wasn't.
But then it wouldn't be such a frightening term.
Have I got this right? Structure. Ground 4 says that the indemnity for which you contend should be implied into contracts of employment generally. And ground 5 says if we're wrong about that, then it should have been implied into this contract at the time it was made because of all the factors set out in paragraph 25. Many of which refer to Romania, to the bank's risk assessment skills and so on. But it's still got to be, hasn't it, that if the officious bystander with nothing else to do had been shown a document informing him or her of all the factors in paragraph 25 at the time the contract was entered into, and had been asked, is it necessary to spell out that if anything goes wrong in terms of unjustified prosecution in a foreign country and so on, the bank will pick up the tab, including possible career loss of earnings, that the officious bystander would have said, it's all right, you don't need to put that in, it's absolutely obvious. Or on the alternative necessity test, that it is necessary to give business efficacy to the contract of employment, that such a term should be written in. It's got to be one of those two things, otherwise it can't be implied.
Well, I accept that, my lord.
Well, the judge has found that it wasn't. Are you asking us to say that it's so obviously wrong that we should declare that it was?
Yes.
Okay, well, that's it.
Okay, well, we know where we are. I also know what time it is, and I'm afraid announce it any longer this afternoon. I will be frank with you. I'm concerned. You've now got, according to your deal with Mr. Goulding, an hour and a quarter tomorrow morning. I'd stretch it to an hour and a half, but not the whole morning anyway, to deal with all the remaining issues in the case. I think you're going to have to think carefully about how to make sure that all the ground is covered in an efficient way. It may well be that you make the correct, maybe your judgment is correct. This is the most important part of the case, and it's important, therefore, to spend a lot of time on it. But still, we've got to understand the other parts. So, will you give that some thought overnight?
Of course, my lord. I will give it some very careful thought. I think I've got.
And you will have to allow for a certain amount of intervention by us. I don't think we've intervened any more than courts can be expected to do. But we won't just sit here and listen, as we want to ask questions to make sure we understand.
Understood. Yes, my lord.
Right. Thank you very much. 9:30 tomorrow.